Hi everyone, I'm Julie Kruger. I'm an immigration lawyer in Buffalo, New York, and I'm the owner of Kruger Immigration Law. Thanks so much for joining us today. Kruger Immigration Law is a small boutique immigration law firm, and we're headquartered in Buffalo, New York. We have a by-appointment office in Toronto, Ontario, Canada. And our practice is limited to immigration law. We do family cases, business cases, removal defense, citizenship and naturalization cases, admissibility issues, border processing, all kinds of immigration cases. You can reach us at www.krugerimmigrationlaw.com. You can call me at 716-393-9878, or you can email me at julie@krugerimmigrationlaw.com. Kruger's Kruger. So thanks so much for joining us today. We are going to be talking today about the new regulations regarding the Affidavit of Support and public charge ground of inadmissibility. So the Affidavit of Support is what an applicant used to do to show that they would not become a public charge in the United States. USCIS has recently announced a dramatic change to that process. So an applicant for a green card or an immigrant visa, or someone coming into the U.S. even as a non-immigrant, is required to show that they're not going to become a public charge in the United States. Basically, that they can support themselves financially and that they are not going to require government assistance. This is one of the oldest parts of immigration law. This has been part of immigration law for a very long time. In previous years, for a long time, how an applicant has shown that they will not become a public charge in the United States is by having their petitioner for their immigrant visa or green card process submit an affidavit of support, the form I-864, and show that their petitioner has sufficient assets to sponsor them or has sufficient income to sponsor them and will take care of them while they're here for a certain period of time. USCIS recently changed this process, and this change is going to take effect October 15th, 2019, this year. So in just about a little over a month, there's going to be a new process in place for applicants to show that they will not become a public charge in the United States. This applies to adjustment of status cases in the United States, the form I-485. This also applies to change of status and extension of status cases. So right now, this does not apply to immigrant visa processing. This does not apply to immigration court cases. It's just the forms I-485, change of status and extension of status cases. I would imagine that as this process gets in place for those types of cases, this new regulation is going to expand out beyond that and apply to other cases as well. But for now, it's just adjustment of status, change of status, extension of status. And the change is heavily focused on putting the burden to show that the applicant is not going to become a public charge on the applicant themselves. So as I said previously, the process always focused on being able to show that the applicant's petitioner could support them in the United States. That is now one factor among many that are considered. So instead of just the petitioner, it's also going to be focused heavily on a whole bunch of factors about the applicant that the applicant is going to have to show. So there's two main parts of this that I want to talk about today in the changes that are being implemented as part of this new rule. And so mainly it's changing the definition of who is considered to be a public charge. And the new definition, and I've got some notes here that I'm looking at just because I want to make sure that I'm giving you all the accurate information. So the new definition of public charge is going to be someone who receives a public benefit or who is likely at any time in the future to receive public benefits at a de minimis or low level, minimum level. And receiving public benefits is one of a specific list of public benefits if that person has received a public benefit for 12 months or longer in any 3-year period in the aggregate. And so what that means by in the aggregate is that, say you receive 3 different benefits, each for 4 months, that would add up in the aggregate to 12 months. So they will add each thing up together to calculate the amount of time that a person has received public benefits. Public benefits includes things like SSI, TANF, SNAP, Medicaid, and Section 8 housing. There are specific exceptions to, for example, Medicaid, where you're receiving it for emergency purposes, or a pregnant woman is receiving Medicaid. That does not necessarily make somebody inadmissible or barred from getting a green card or changing or extending their status based on that they're going to become a public charge. Things that are not on the list include WIC, Obamacare, the Earned Income Tax Credit, and then there are a whole variety of people who are specifically excluded from this. So, for example, military families and children who automatically become citizens upon living with a parent that are accepted from this. Intended immigrants are not imputed with benefits that are received by other persons. So just because your parent may have received public benefits does not necessarily mean that you are going to receive public benefits. You're not faulted for that. And the important thing to note is with these definitions that this does start October 15th. So these are going to be from applications filed on or before October 15th, on or after October 15th, but that you do still need to disclose public benefits received before October 15th. And so that's really important to note as well when you're completing the forms that are required for this, that even though this form is only going forward, this change is only going forward, you still need to disclose previous receipt of public benefits. So that's one part of the change, is that the definition of a public benefit, of who's going to become a public charge, has changed. And the other part of it is going to be how USCIS assesses whether or not someone is likely to become a public charge in the future. So that they've come up with a 7-part test that an applicant is going to have to show that they meet all of these things and the different factors that USCIS is going to consider to determine whether or not somebody's going to become a public charge. The first of these factors that they are going to consider is age. If the person is of working age, which is going to be considered 18 to 65, is going to be a presumed working age, that is going to be positive, a positive factor. If outside of that time period, if younger than 18 or older than 65, that's going to be considered a risk factor. Health is the second factor. So if an applicant has a condition that impacts their ability to work or requires long-term care, that's going to be a negative factor and something that USCIS is going to consider means someone was more likely to become a public charge. This is going to be based largely on the medical exam. So if that's something that the adjudicator is going to look at. That's something that has always had to be submitted with an adjustment of status application. Previously, that medical exam has always been focused on establishing whether or not someone has a communicable disease of public health significance. So what we don't know is, will the medical exam be expanded to consider other areas of health to help determine whether or not that person is going to become a public charge. The next factor is going to be the person's family status, and that's going to be how many people are in their household, and is going to define who is counted in the person's household. And thanks so much for joining us, Sarah. And that's going to include the applicant's spouse, resident children, non-resident dependents who receive more than 50% of support from the applicant. So if the applicant's income is going to be more than 125% of the poverty guidelines for that number of people in a household. So there's a chart on the USCIS website that's available that shows how many people are in a household and what 125% of the poverty guidelines is for that number of people in a specific household. So USCIS is going to look at how many people are in the applicant's household and go across that line. What is 125% of the poverty guidelines, and is the applicant's income more than 125% of those poverty guidelines? This is has been used on the Affidavit of Support previously, but again focused on the petitioner. Now this will be focused on the applicant. The next factor that USCIS is going to look at is going to be the applicant's financial status. So this is going to include things like the applicant's credit score, any debts the applicant has, such as mortgages, student loans, other types of loans. It is going to be a consideration of any assets that the applicant has. The one thing to note is that income from unauthorized employment can be included in this. So that's a change from previously from the Affidavit of Support. Previously unauthorized employment would not be used. The next factor that USCIS is going to look at is going to be the applicant's education and skills. So USCIS is going to consider their job history, their formal education, any formally documented working skills or job skills, such as if you have a certificate in some specific area. They are looking for at least a high school diploma or greater, and they also want proof of English language ability. So if it's not totally clear yet how this specific requirement is going to be evaluated, assuming that if the person is from an English-speaking country, that they will speak English, but if not from an English-speaking country, and a person has not gone through any kind of formal education process to show that they have the ability to speak English or could produce a certificate saying that they've taken English courses, it's not clear how a person might be able to document just simply the fact that they speak English because they've learned it. So this will be a place that we'll learn more about as this rule gets implemented. And this isn't a requirement anywhere else in immigration law for applicants applying for benefits like a visa or a green card. So that's something that's really dramatically different than previously. Thanks so much for joining us, Richard. So the next factor is going to be the applicant's anticipated period of admission. So what this means is that they're going to consider how long the applicant is planning to remain in the United States. So is the applicant a non-immigrant visitor for pleasure? They're coming for vacation, they're going to be here for 2 weeks. Or is the applicant applying for a green card and is going to remain in the United States permanently, live and work for the rest of their life in the United States? So that's going to be something that USCIS is going to look at. How long does the person need to be supported or need to show that they have the ability to support themselves in the United States? And then the last factor that they're going to consider is the Affidavit of Support. So the Affidavit of Support from the petitioner is still going to be a part of the application process, but it is just going to be one factor among these 7 factors that they're going to look at. And as we understand it, the Affidavit of Support is going to be considered a little bit differently, and co-sponsors are going to be disfavored, and co-sponsors who are not living with the applicant or are not related to the applicant are going to be more problematic. So in the past, anybody could be a co-sponsor as long as they meet the requirements, over the age of 18, living in the U.S., be a U.S. citizen or green card holder, and have the ability to support that person. Now USCIS is going to look more closely at how is that person related to the applicant, what is the likelihood that they're really going to actually sponsor that person. So those are those 7 factors that USCIS is going to look at: age, health, family status, financial status, education and skills, the anticipated period that the person is going to be admitted, and the affidavit of support. The way that USCIS is going to analyze these factors is the applicant is going to be required to submit the form I-944, Declaration of Self-Sufficiency. So this is a new form, and the final version of the form has not yet been published, so we haven't seen it. But the form in its draft forms that have been released is a long form. It's about 15 pages. It is going to be a significant burden on the applicants to complete the form and to provide the supporting documentation that goes along with the form. Some of that supporting documentation is going to include 3 years of tax transcripts, not the copies of the returns, but the tax transcripts from the IRS, credit reports, documentation of any untaxed income, licensed appraisals of real estate, health insurance policies, child support orders, documentation of loans, everything that is listed on the form, all of the questions, your answers will need to be documented with supporting documentation. So that's going to be, the form itself is a significant burden to complete, and then the supporting documentation is going to be a real burden on the applicant. One of the things to note with when the adjudicator is looking at these applications from USCIS and making the determination based on all these factors, whether or not the applicant is going to become a public charge, is that the applicant has a lot of discretion, or the adjudicator has a lot of discretion in making that decision. They're going to look at all of these factors and that officer is going to make a determination as to whether or not that person is going to become a public charge. So that officer is going to have a lot of discretion. In addition to those 7 factors we've just talked about, the officer can also consider a variety of heavily weighted considerations. And so, for example, those are going to include like negative factors, such as a person who's not working and doesn't have an offer of employment, a person who's currently receiving public benefits, a person who has an expensive medical condition or is uninsured, and any kind of prior finding of inadmissibility by an immigration judge or by the Board of Immigration Appeals. Positive factors are going to be if the applicant's household income is at or above 250% of the federal poverty guidelines, including their assets. Having private health insurance is also going to be a positive factor. So when the adjudicator is making the decision on this application, they're reviewing that form I-944, they're reviewing the medical exam, they're reviewing all of that supporting documentation, they're looking at those 7 factors, they're looking at other heavily weighted considerations. So there's a lot of different factors that are going to go into making this decision on whether or not someone's going to become a public charge. If that officer feels that that person is going to become a public charge, that determination can lead to a denial of the application. So even though you might qualify for all of the other reasons on an application, you may be denied because you've been determined to be a public charge. If the officer feels like the applicant is close or could go either way, the officer does have the discretion to require that the applicant post what's called a bond. And the minimum bond will be $8,100. So that's quite a burden for someone who's already having trouble showing that they're not going to become a public charge. That's going to be a significant amount. So the officer has the discretion to say, you can post this bond, and by posting this bond, you will satisfy the requirement that you are not going to become a public charge. This is something you can't offer it yourself to begin with. This is something that has to be determined by the officer, and they have the determination to set the bond and to set the amount of the bond. And that bond is going to be cash or cash equivalent, and there's once the time period for the bond is over, then the applicant will need to apply for that bond to be canceled to get their money back. So those are the main new changes. So USCIS new regulation on the public charge requirements. These regulations begin October 15th of 2019, this year. And any application that is received by USCIS on or after October 15th will be subject to these new rules. If you are in the process of applying right now, I would recommend that you try to get your application filed before October 15th so that you do not have to be subject to these new rules and this new burden of filing the Form I-944 with the supporting documentation, because it is going to be a significant burden. If you are going to be filing on or after October 15th, I would strongly recommend that you consult with an immigration attorney to talk about whether or not you might be subject to the public charge ground of inadmissibility based on this new regulation, and whether or not you need an attorney's assistance in preparing these new forms and preparing the supporting documentation that go along with it, because these grounds can lead to a denial. So those are the main things that we wanted to talk about today. New ground of inadmissibility, public charge definition is changing, and there's a 7-factor weighted test to look at whether or not USCIS is going to determine someone's a public charge. So thanks so much for joining us today. I really appreciate you being here. If you would like to speak with me more about this, please give me a call. My phone number is 716-393-9878. You can email me at julie@krugerimmigrationlaw.com. You can find our website at www.krugerimmigrationlaw.com, and you can submit an inquiry through the website. Thanks so much. I really enjoyed being here with you today. Have a great day.